On the 2nd of August, 1986, Diane Sindall finished a shift behind the bar at the Wellington in Bebington and set off home. She was 21 years old. She worked in her family's floristry business during the day, and she took bar shifts in the evenings for one reason. She was engaged, and she was saving for her wedding. It was booked for the following year. She never got home. Diane Sindall was murdered that night. 40 years later, nobody has ever been correctly convicted of it. And the DNA of the man who killed her has never been matched to a name. One man was. He spent 38 years in prison for it. He was innocent, and the system that eventually proved it made no mistakes along the way. This is the story of Diane Sindall, of Peter Sullivan, and of a decision taken in 2008 that was completely correct and cost a man 17 more years of his life. If you're new here, this channel covers cases where the law itself is the story, the rules, the procedures, and the gaps almost nobody knows are there until a family finds one. If that's the kind of thing you want more of, subscribing takes a second. Start with Diane, because most accounts of this case do not. She was 21, and she lived on the Wirral, dividing her time between her fiancé's home in Seacombe and her parents' house in Tranmere. Her parents have been named in reporting as Wendy and Brian Sindall. Her fiancé was David Beattie. She worked in the family's floristry business. In the evenings, she pulled pints at the Wellington in Bebington, and the reason she did both is the detail that matters most about her. She and David were getting married in 1987. The bar shifts were for the wedding. A Liverpool Echo feature years later described her as vivacious, bubbly, and happy-go-lucky. That is not very much. It is, as far as I can establish, most of what the public record holds about who Diane Sindall was, and there is a reason for that, which I will come back to. On the night of the 2nd of August, 1986, she finished her shift at the Wellington and set off home. She was murdered in Birkenhead. The honest position is that the public record of Diane Sindall's life is thinner than it should be, and there is a reason for that. For 38 years, almost everything written about this case was written about the man convicted of killing her. His conviction, his appeals, his name in the headlines. Her name appeared in those stories as the reason his existed. That is what happens when a wrongful conviction runs for 4 decades. The victim becomes a fact in someone else's story. She was not a fact. She was 21. She had 2 jobs, and she was going home. And there is something specific about the shape of that. Most murder victims are remembered through the trial of the person who killed them, the evidence, the sentencing remarks, the family statements read to a court. The record of who they were gets assembled as part of the record of what happened to them. Diane Sindall never got that, because the trial that happened in 1987 was about the wrong man. Everything said about her in that courtroom was said in support of a conclusion that has now been quashed. 38 years of documentation, and almost none of it is a reliable account of anything. The people of Birkenhead remembered her anyway, and they did it themselves. In the weeks after she was killed, women across the Wirral organized a Reclaim the Night march through Birkenhead. Hundreds of women and girls walked it. Around the same time, a group of local women started a rape crisis counseling service. It began by the account of the people who were there, around somebody's kitchen table. It was formally registered in September 1987. It is still running today as Rasa Merseyside, and it has been operating for very nearly 40 years. It exists because Diane Sindall was murdered. And on the 8th of March, 1988, International Women's Day, a memorial stone was unveiled on a grass verge on Borough Road in Birkenhead. Local women raised the money for it. Local women wrote the wording. It reads, Diane Sindall, murdered August 2nd, 1986, because she was a woman. In memory of all our sisters who have been raped and murdered, we will never let it be forgotten. Read the second sentence again. It is not only about her. The women who paid for that stone chose to make it about every woman it could have been about. Flowers still appear on it. RASA still marks the anniversary. The council keeps it clean. Nobody in an official position built that. It was built by women in Birkenhead who decided that the thing they were most afraid of was that this would be forgotten. In September 1986, Merseyside police arrested a man named Peter Sullivan. He was interviewed 22 times over 4 weeks. During those interviews, according to the Criminal Cases Review Commission, he was not provided with an appropriate adult, and he was denied initial legal representation. An appropriate adult is a safeguard. Under the Police and Criminal Evidence Act, which had come into force the previous year, certain people questioned by police, including those who are vulnerable, are entitled to have an independent adult present. The role is not legal. The appropriate adult is there to make sure the person understands what is happening, that questioning is fair, and that they can communicate. Peter Sullivan did not have one. 22 interviews is also a number worth sitting with. Not 22 hours. 22 separate interviews across 4 weeks with the same man about the same night. Research into false confessions and unreliable admissions consistently identifies repeated questioning over an extended period as one of the conditions under which people say things that are not true. Not because they are lying, but because sustained questioning wears down a person's ability to hold a line, and because the interview itself starts to feel like something that will only end when the questioner is satisfied. That is why the safeguards exist. That is why the Police and Criminal Evidence Act had been brought in the year before, and why the appropriate adult provision is in it. In 1987, he was convicted of the murder of Diane Sindall and sentenced to life imprisonment with a minimum term of 16 years. He said he had not done it. He said it in 1987, and he never stopped saying it. 16 years came and went. He stayed in prison because parole is not automatic, and because a man who will not admit to a murder is a man who has not, in the language of the system, demonstrated remorse or addressed his offending behavior. He served 38 years. Think about the arithmetic of that for a moment. He went into prison in 1987, the year the first mobile phone network in Britain was 3 years old. He came out in 2025. He was 30 when the cell door closed and 68 when it opened. The minimum term was 16 years. He served that, and then he served 22 more, and the reason he served them is that he would not say he had done it. There is a particular cruelty in that mechanism, and it is not anybody's fault. Parole boards are asked to assess risk, and a person who denies the offense cannot demonstrate that they have addressed it. The system has no way of distinguishing between a guilty man refusing to admit it and an innocent man telling the truth. It treats them identically, and it keeps them both. In 2008, 21 years into the sentence, Peter Sullivan applied to the Criminal Cases Review Commission. You need to know what that body is, because it is the center of this story. The CCRC is an independent organization set up under the Criminal Appeal Act, 1995. It reviews convictions where someone says a miscarriage of justice has occurred. It is based in Birmingham and funded by the Ministry of Justice, and it is deliberately separate from both the police and the courts. It has one significant power. It can refer a conviction back to the Court of Appeal. But it cannot do that whenever it thinks a conviction looks wrong. The test is specific. There must be a real possibility that the Court of Appeal would find the conviction unsafe, and ordinarily that requires something new. New evidence or a new argument that was not before the court the first time. That threshold exists for a reason. Every conviction in the country could be described as arguable by someone. If the CCRC referred cases on the strength of doubt alone, the Court of Appeal would be permanently occupied, and the referral would mean nothing. The bar is what makes a referral significant when it happens. In 2008, Peter Sullivan raised concerns about the DNA evidence. The CCRC consulted the experts of the day. The Forensic Science Service advised that further testing of the samples would be very unlikely to produce a DNA profile. The CCRC did not refer the case. Now, here is the part that makes this case different from almost every wrongful conviction story you have heard, and it is worth being precise about it. That decision was correct, not defensible, not understandable in hindsight. Correct. When the Court of Appeal came to look at all of this in 2025, Lord Justice Holroyd said the 2008 decision was plainly correct. To understand why, you have to understand what the samples were. Biological material recovered from a crime scene in 1986 is finite. There is a fixed amount of it, and every test consumes some. The techniques available in 2008 were significantly less sensitive than the techniques available now. They needed more material to produce a result. And with a degraded sample from 22 years earlier, the probability of getting a usable profile was low. Which creates a genuinely difficult problem. Testing in 2008 would probably have failed. And in failing, it would have used up material that might one day be tested by something better. Spend it now on a test that will probably not work, or keep it and wait for science that does not exist yet. The CCRC kept it. It is worth being clear that this was not a hopeful gamble on future technology. Forensic science has a general principle that runs through every discipline in it. Do not consume evidence unnecessarily. Physical material is irreplaceable. Once a sample is used, there is no second attempt, no reanalysis, no independent check by anyone else. That principle exists mainly to protect against error and against unfairness, to make sure a defense expert can test what a prosecution expert tested. Here, it did something nobody designed it to do. It kept a sample intact for 13 more years, until a method existed that could read it, the right decision, made for ordinary reasons, quietly preserving the only thing that would ever prove a man innocent. This is the point in the story where the frustration usually starts, and I want to be careful about where it goes. If you're still with me, a like on this video genuinely helps it reach people, and there's a turn coming that most coverage of this case leaves out entirely. Peter Sullivan did not stop. In 2019, he applied directly to the Court of Appeal without the CCRC, arguing about bite mark evidence that had been used in his trial. In 2021, that appeal was dismissed. The court found the bite mark evidence had not been central to the prosecution case. 2 months later, in March 2021, he applied to the CCRC for a second time. He raised 3 things: the police interviews, the bite mark evidence, and what had been said at trial to be the murder weapon. None of those were the thing that freed him. What freed him was that the CCRC, on receiving the second application, decided to revisit the question of DNA testing. The techniques available in 2021 were not the techniques available in 2008. The CCRC has said so directly the scientific methods it relied on in the second review did not exist at the time of the first. The samples were still there, 35 years old, and still there, because in 2008 somebody had decided not to spend them. They were tested. A DNA profile was obtained. It did not match Peter Sullivan. 35 years after Diane Sindall was killed, and 13 years after a decision not to test, the material finally answered the question it had been holding the entire time. In November 2024, the CCRC referred his conviction to the Court of Appeal, describing it as potentially unsafe. The hearing was on the 13th of May 2025, before Lord Justice Holroyd, Mr. Justice Goss, and Mr. Justice Bryan. Counsel for Peter Sullivan told the court that the new evidence showed Diane Sindall's killer was not the defendant. And then something happened that does not happen often at the Court of Appeal. The Crown Prosecution Service did not fight it. Duncan Atkinson, KC, for the CPS, told the court there was no credible basis on which the appeal could be opposed. The CPS said in writing that the new DNA evidence was reliable and that it was sufficient fundamentally to cast doubt on the safety of the conviction. It did not argue that the evidence was incapable of undermining it. The court said it had no doubt that admitting the evidence was both necessary and expedient in the interests of justice. The conviction was quashed. It was quashed on the DNA alone, not on the interviews, not on the bite mark evidence, not on the murder weapon. The court dealt with the other grounds and did not need them. Peter Sullivan attended by video link from HMP Wakefield. He wept and held his head in his hands. He was 68 years old. He had been in prison since he was 30. His sister, Kim Smith, spoke to reporters outside the Royal Courts of Justice. Asked afterwards how he felt, Peter Sullivan said he was not angry. That is where most accounts of this case stop. They should not, because the most important thing about it has not been said yet. Diane Sindall's murder is unsolved, and the investigation is not dormant. It is one of the most active cold case inquiries in the country right now. Merseyside Police reopened it in 2023 after the CCRC's DNA work. A dedicated team has been running it since, latterly under Detective Superintendent Rachel Wilson, with specialist support from the National Crime Agency. The DNA profile recovered from 1986 belongs to a man. It does not match Peter Sullivan. It does not match David Beatty. It does not match any member of Diane Sindall's family. And it does not match anybody on the National DNA Database. So the force has been eliminating people by hand, one at a time, by voluntary sample. By May 2025, the figure was over 260. By November, it was 456. By early 2026, around 500. By the 40th anniversary, the 31st of July 2026, 575 people had been eliminated, with 32 still under review. Samples have been taken from people connected to the original inquiry, from relatives, and from further afield, in the United Kingdom and overseas. Crime Stoppers has a £20,000 reward standing. There was a Crime Watch live appeal in March 2026. Diane's family took part in it. 40 years, 575 eliminations, and no name. Detective Chief Superintendent Karen Jondrill of Merseyside Police said after the hearing that the force's thoughts remained with the family and friends of Diane Sindall, who continue to mourn her loss, and who would have to endure the implications of this development so many years after her murder. Read that carefully. Her family were told in 1987 that the man who killed her had been convicted. They lived with that for 38 years. In May 2025, they were told it was not true, and that the question of who killed her is open again. Two people's lives were taken by the same wrong answer. Diane Sindall's and 38 years of Peter Sullivan's. And the person actually responsible has never answered for either. There is one more chapter, and it is still being written. In July 2025, the Independent Office for Police Conduct wrote to Merseyside Police about the case. The force confirmed it had received no complaints and had identified no potential misconduct connected to Peter Sullivan's conviction. The IOPC advised that a referral should be made if that changed. In November 2025, the BBC broadcast an interview with Peter Sullivan in which he raised a number of concerns about how Merseyside Police had handled the case. In January 2026, a complaint was referred to the IOPC on the basis of that interview. the IOPC has opened an independent investigation. Nothing has been decided. No finding has been made. What is on the record from the CCRC is that during 4 weeks of questioning in 1986, he was interviewed 22 times without an appropriate adult and denied initial legal representation. Whether that amounted to misconduct is precisely what is being examined now, and it is not for this film to answer. If you have stayed this far, you are the kind of person these videos are made for. Subscribing tells me to keep making them. So what does this case actually show? Not that the system failed him, although it obviously did. Something more uncomfortable than that. Every individual decision along the way was reasonable on the information available at the time. A jury in 1987 convicted on the evidence it was given. The CCRC in 2008 declined to refer, and the Court of Appeal has since confirmed that was plainly correct. The Court of Appeal in 2021 dismissed an appeal on bite mark evidence, having found it was not central to the case. The CPS in 2025, faced with a DNA profile that was not his, declined to oppose the appeal at all. Nobody in that chain did the wrong thing with what they had. And it took 38 years. Because the thing that eventually freed Peter Sullivan was not a person noticing something. It was not diligence or persistence or a campaign, although his own persistence is the reason there was anything to test. It was a laboratory technique that did not exist when he was convicted, did not exist when he first asked, and had to be invented before anyone could use it. There is no version of this case where the system catches it earlier. The evidence that proves innocence was, for 35 years, unreadable. It was sitting in a store, intact, saying nothing, because nobody on earth yet knew how to make it speak. The only decision that mattered was the decision not to use it up. Somebody in 2008 chose to leave a sample alone because the test would probably fail. That person had no idea what they were preserving. They were not being clever. They were following a procedure that says, do not spend evidence you cannot afford to lose. That procedure is the reason a man is out of prison. Diane Sindall was 21. She worked in her family's flower shop. She pulled pints at the Wellington in the evenings, and she was saving for a wedding in 1987. Her memorial stone is on Borough Road in Birkenhead, and it was paid for by women who did not know her. Peter Sullivan was 30 when he went into prison and 68 when he came out. He said he was not angry, and somewhere there is a man whose DNA was recovered from that scene in 1986, who has been eliminated from nobody's list because nobody knows his name. 40 years on, Merseyside police are still asking. If you were in Birkenhead that summer, if you remember something about somebody's behavior that August, if you have carried something for 4 decades, there is a Crime Stoppers line and a £20,000 reward, and you can do it anonymously. That case is still open.